Okay. We can go.
You have it in the light? And you get to say what it was.
Would that be okay if I said a quick word?
Absolutely. Okay, you go first, and I'll give
Well, I can just show it
Oh,
right now.
yeah, go ahead.
Okay, Russian 160, your class is the lecture, but I am going to email out a question after the lecture that you'll just have to respond a very short response via email to me by the end of the day. So just plan to do that, and then, but will we have time for a Q&A?
Yes.
Okay. Feel free to ask any of your questions later, but I'll turn it over to Dr. Burkov, Dr. Lucy, and others.
I'll turn it over to Leonard Hammer. You know, it's a big event when somebody introduces somebody to introduce somebody else.
I know. This is a lot of fun. Complicated. Okay. Is it working? Yeah. Brilliant. Okay. Awesome. All right. Well, welcome everybody. Sorry we got a little bit late, but I think it'll definitely pay off. I have the pleasure of introducing to you Professor Anton Burkov from the University of the Urals, coming here. He's also representing his own Strategic Litigation Center, which is an NGO that he started, he'll be describing a lot of the work that the SLC, that the Strategic Litigation Center does. I have the pleasure of working with Professor Burkov for close to 10 years now, and he's actually here on a research development grant at the University of Arizona, specifically to work with our MA program in human rights practice to develop dual language programming between his university and our university here. And his specialty is human rights. He's worked on incredible cases, which he'll be talking about today. And with that, I will give the floor to Professor Burkov. Thank you for coming.
Thank you. I will use both hands to navigate. Thank you for your time. Thank you for coming here today. I wanted to share with you today the Russian experience of my colleagues, my own experience on how we deal, how regular, usual, common citizens use European Convention of Human Rights, how they apply to the European Court of Human Rights to protect their rights, to defend their rights, and how we actually strategically litigate cases, how we bring international human rights home. A few words about the NGO Strategic Litigation Center. The idea of this NGO was flying around for some time. We formally set up this center last year. Its goal is to strategically litigate complicated cases, to be able to bring a big impact, which can have consequences not just for the client, not for the applicant in the particular case, but touch the entire class of people. Sometimes it's entire Russia and even foreign citizens. Another goal of this organization is to share this experience. That's why we publish books. I have a couple of books with me in Russian, some literature is in English I can share with you. It's all free. I'm going to donate these books to the library. And also through lecturing and the recent initiative together with your university, online trainings. So we actually break boundaries that people all over from Russia can is able to learn this experience, how to bring cases. So strategic litigation or impact litigation, as I said, is equipped to influence an unlimited number of circle of people. And the main goal of strategic litigation is not to win in the court of law, but to win in the court of minds of people. So you have to capture the attention of the people, judges, journalists, politicians, and then the change might happen. It's never happening like this. Imagine how many years it took for the Brown versus Board of Education to come around. many cases, many years. So it's the same here. So social change, the bigger social change that we're trying to bring is we're trying to make this change in the mind of lawyers that international European human rights law, it's not for an international court to use. It's for the national courts, a peace court, a judge, a district court judge, to apply international treaties in his or her decisions. And we do this since 1998, since Russia ratified the European Convention. So last February it was 23 years since Russia became a member of the Council of Europe. It's an international organization. Some people mix it with, confuse it with the European Union. It's absolutely different organization. It's not an economic union, it's a political union. And the aim is to uphold human rights, democracy, and the rule of law. It was founded in 1994, has 47 member states, a budget half billion, and Russia contributed 30 million per year. But the last 2 years, Russia refused to pay this contribution. That's a separate story. Sorry, we do not have time to discuss this. This is the anthem of the EU, and the Council of Europe has the same flag, the same anthem. Sorry, there is no sound here. And there's a hip-hop version. Sorry you don't hear it. It's kind of fun. So there are three main organs of this Council of Europe: Parliamentary Assembly of the Council of Europe, Committee of Ministers, executing organ, consists of ministers, foreign ministers, the deputies, and the European Court of Human Rights. And we speak more about the European Court of Human Rights. That's the building. It's called Human Rights Building. This is a courtroom. Unfortunately, hearings do not take place very often. It's solely written exchange of memos. So what the European Court of Human Rights do? It's an international court based in Strasbourg, like all the organs of the Council of Europe. It consists of judges, each one coming from each member state. But those judges are independent. They do not represent a particular country. Like a Russian judge does not represent Russia. Of course, there is a secretariat, also consists of independent lawyers. It was established by the European Convention on Human Rights. It's an international treaty which only member states of the Council of Europe can ratify. US cannot be a member of the European Convention. So it's established the European Court, and the convention lists rights that are protected by this convention. Not all of the rights possible are incorporated in the European Convention. So that's why to my clients I say sometimes the European Convention cannot do anything for you. These are the list of rights. It starts from the right to life, freedom from torture, inhuman and degrading treatment, all the political rights, some of the economic rights too, right to be elected, also protected, but only very limited way, but it is there. So what does the European Court do? It applies the European Convention if member states failed to apply these guarantees within the national legal system. Basically, European Court issues judgments which are legally binding on other states. I often compare this with US Supreme Court. Its judgments are legally binding for each state of the United States of America. So it's very, very much similar. It can issue judgment, can give compensations. They can be from 1,000 euros to $1 billion. The biggest number they awarded was to the oil company UCAS, almost 2 billion euros. It can also prescribe changes in the national law, which is very controversial because of the sovereignty, the notion of the sovereignty. Individual measures, European Court can prescribe that somebody is to be released from a prison. This is a system how the particular case go around the different divisions of the court. A single judge can consider very simple issues like inadmissibility. 3 judges can consider a very simple case on a very well-established case law. Usually 7 judges, a chamber of 7 judges consider cases. And the grand chamber is for the most important cases which might change the case law of the entire court. And the most important question is when we can apply to the European Court of Human Rights. There are very complicated rules of admissibility. Unfortunately, 95% of all the applications coming to the European Court of Human Rights are inadmissible because applicants, their lawyers, do not often follow these rules. But the most important rule is we can apply to the European Court after exhausting domestic remedies. This is the main idea. You first try it in the national court, and then you go to the European Court of Human Rights. So this is the main idea of the European Convention and of the European Court of Human Rights. Most of the lawyers forget that the European Convention actually starts with Article 1, not Article 2, right to life. And Article 1 set up this major rule that member states, the high contracting parties which ratify the European Convention, they shall secure the rights enshrined in the European Convention at the domestic level. And when Russia ratified the convention in May 1998, not many lawyers understood the idea of the European Convention. Everybody, or majority of the people, lawyers, thought that, okay, Russia ratified the European Convention, now we have a right to apply to the European Court of Human Rights. No. First of all, you've got a right to use European Convention at the domestic level. And the European Convention is not just the text, it's a train of case law judgments of the European Court of Human Rights which interpret the text of the European Convention. So that's the tool that every lawyer can use. So that's what we were doing by litigating cases. We're trying, in addition to just the particular goal to win a particular case, to change a particular legislation, we would educate judges and lawyers to the simple idea that the European Court is a secondary. First of all, you have to go to the national courts. And the case law of the European Court of Human Rights is legally binding in interpreting the convention, and they are legally binding for Russian judges. And it was very important to do this because you can see through this example. This is the interview, online interview, which Chief Justice of Regional Court in Ekaterinburg conducted in 2004, and I asked this judge whether they organize any trainings for lower judges on the European Convention, and he said no, it's not necessary. All we need is to apply national law. The most funny thing is this interview press conference was called "Judges Shall Know Everything," but probably not the European Convention. And another interesting fact that in 2003, this particular court, was responsible for one of the first judgments of the European Court against Russia, where a woman was held in psychiatric hospital for 40 days. She was treated with a very heavy medicine without a court decision. And that's why, because it happened because they applied Russian law, not the European Convention. So we used strategy to bring down resistance to the European Convention. I remember 98, 99 when I would come to the judge and argue the case based on the European Convention and the case law, and the judge would say, stop, one more time you mention the convention, you're going to be out of my room, of the courtroom. We're here not to just apply foreign law. The understanding was that European Convention is a foreign law, it's not a national law. So you really have to make an effort to make this shift in the minds. So we were arguing cases. If they are not successful at the national level, we'll bring the case to the European Court and then come back with the judgment of the European Court and educate judges once again. We do this through education. We organize a special offline school. We call it URLS, International Human Rights School. We will train Russian litigators, young lawyers, to these ideas, publishing books, speaking at conferences. And there was a progress. Many NGOs in Russia picked up this idea of using European Convention at the national level. So many NGOs started to do this, and the impact was much more, much wider. Before 2003, very little cases where judges applied the European Convention. For example, Supreme Court never actually referred to the case law. But if you refer to the convention without looking at the case law, that's a wrong way of applying it, because you have no idea what you're doing. But then today, Supreme Court, Constitutional Court of Russia use the European Convention very well, sometimes, with very good examples, even in the cases that I'm going to talk about today. And Anatoly Kovler is a former judge who served at the court of the European Court for 12 years. He studied many cases coming from national courts, and he arrived at this conclusion: the further you are from Moscow, the better courts apply the European Convention. He said it at a conference where the Chief Justice of the Moscow City Court was present. And this judge wasn't so happy about this conclusion. But there is no progress if the case is about changing the Russian law. If application of the European Convention will bring law reform, will bring reform of the judicial practice. And if the cases are sensitive, like transplantology, like right of lifers, you can read it, right of terrorists. Very many life prisoners are accused, convicted terrorists. So I'm going to share with you two cases. They are all about bioethical issues. I call this, it's a set of cases. It's not just two cases, it's two sets of many cases on two issues. Right to artificial insemination and conjugal meetings. It's the right of prisoners and their family members. And another case is called secret organ harvesting case. Although those cases are absolutely different issues, but there are a number of features which are common for those cases. Those issues has never been considered by the European Court of Human Rights against Russia. So there's no judgment like Petrov versus Russia on the right of conjugal meetings. But those issues were considered by the European Court against other states. But according to the position of the Russian Supreme Court, even if the judgment of the European Court is against like UK or Poland, it's still legally binding on Russia if the same issues are at stake. So Russian judges have to take into account even cases against other states. Applicants have a case only if they rely on the European Convention. If they look at the Russian law doesn't protect them, doesn't protect their rights. All of those cases, if resolved under the European Convention, it means it will bring changes to the Russian law or practice. And issues are sensitive. Transplantation, right of lifers. So what strategies did we use? The same. We would put an obvious question before a judge. It's a balance. On one hand, there is a Russian law, on the other hand is the European Convention, and under the Russian Constitution, if there is a contradiction between Russian law and the European Convention, a judge shall apply European law. So it's very easy for a judge to decide, but in practice it's not very easy. Usually judges very much hesitate to apply European Convention in these kind of cases, and we record this hesitation, this behavior, how they try to substantiate their decision. Sometimes the judgments are funny. We package this reaction into the application to the European Court of Human Rights and wait for European judges to evaluate this and then come back to the national courts again. We engage the media, we teach, we publish, and sometimes we bring defendants to the conference, like what happened in the case of organ harvesting case. And the first case is a conjugal meeting case and artificial insemination. It's called Korolyov's case. The family of Korolyovs brought this case. But before that, I will speak about, so 1997, there was a new law on the rights of prisoners, and this law said there is no right to conjugal meetings during the first 10 plus years of serving the sentence. It's called strict regime, no meetings. They were only allowed to have 4 hours meetings through the glass, through the bars. So we have this couple approaching her, Zakharkins. Her husband was convicted criminal for life. She wanted to have a child from him anyway, but the new law didn't allow them any conjugal meetings, so they wanted to challenge that. We took this case to the Russian Constitutional Court. Before, back then, 10 years ago, it was possible to bring a case right to the Supreme Constitutional Court. And the Constitutional Court said it's absolutely ignored the right of the wife. There were two applications, one application on behalf of 2 people, a prisoner and a free woman, not accused, not convicted person. And the Constitutional Court said the prisoner may be limited in the possibility of having a child. So imprisonment means rejection of all the rights. And then there was this Harashenko. He didn't have a wife. He just wanted to have conjugal meetings with his family members, father, mother. So they just spend a few days together in one room, talk, touch each other, enjoy the company. And the court said he may be limited in family life. So we created bad precedents. What do? We wait for new applicants to come over and try to overcome this. Unfortunately, the first case, the Hartman case, was not accepted by the European Court of Human Rights. But Harashenko was, and we will come to this later. So in 2003, Korolyov's family approached us, and knowing our bad precedent that we created 10 years ago, we thought we're not going to go to the court asking for conjugal meetings. It's obvious. Law against us, Constitutional Court is against us. We will ask for the right to artificial insemination. If the state doesn't allow them to have sex, to conceive a child through natural ways, let them do it artificially. One more thing I didn't mention. Back in 2004, we didn't have any case law of the European Court on this issue, on the right to conjugal meetings or artificial insemination. But in 2013, we already had a judgment, Dixon versus UK of 2007, where where the court, European court, said the couple, absolutely similar situation, lifer, prisoners and free wife, they have a right to artificial insemination, but that was against the UK. But we used this case to bring a case to the national courts, to the district court on the right to artificial insemination, and we lost it again. Russian judge, the district court judge said, this is not a case against Russia, so it's not applicable. This absolutely contradicts to the jurisprudence of the Supreme Court. We were exhausting domestic remedies, going through different appeals, and at the stage of the Supreme Court, we learned about Hartman versus Russia case. That's the guy who lost the case just 10 years ago in the Constitutional Court. And the Grand Chamber, 17 judges of the European Court of Human Rights, decided that no conjugal meetings for 10 years is a violation of the right to family life and private life. 2 judges, including Russian one, had a separate opinion saying it's not only a violation of right to family life, it is also in itself, it's inhuman treatment. 10 years without possibility of touching your mother, or mother touching her son. So we got this judgment, translated it into Russian, all the judgments of the European Court, or in English or French. We translated it, published in a law journal, and we sent a letter to the head of the prison where Korolev was held, asking for one conjugal meeting based on the case law, on the Hartman case. The head of the prison said, no, it's not necessary. Just in 10 years, you will get this right. Why bother now? So we took this rejection and appealed it before district court. But this time we were asking, in 2004 we were asking for artificial insemination, but this time we were asking for the right to conjugal meetings based on Hartman case. And this time we won in the district court level. I was absolutely amazed. I didn't expect it at all, but a district court judge has a nerve. She was so brave to issue a judgment which contradicted the case law of the Constitutional Court. She directly applied Hartman versus Russia. Unfortunately, Moscow City Court, as the former ECHR judge Kobler mentioned, Moscow City Court overruled, and we decided to go to the Constitutional Court. Once again, 11 years after we went, 12 years later, we went to the Constitutional Court once again. Again, this is another strategy. We also found 3 more families who brought the case to the Constitutional Court. We did it in case that if for some reason Korolev do not want to continue, so we have a sort of backup other applicants. So the Constitutional Court in 2016 ruled in favor of the family, of Korolev's family. And it overruled its own position, 12 years old position. And then I remember this day when I was sitting at the desk composing the application to the Constitutional Court, and I was thinking, how do I convince 19 judges of this highest court to overrule its opinion which they had 12 years ago? And in the case where one of the applicants is a terrorist. And then I thought, I don't want to argue with them. Let them argue. So Constitutional Court judges argue with the 17 judges of the Grand Chamber of the European Court of Human Rights. So basically, literally copy and paste arguments from the judgments of the European Court into the application and send it to the Constitutional Court. And they beautifully applied the ECHR arguments. Everything was, to my students, I mentioned this case as a good example of Russian courts following the judgment of the European Court. In this judgment, Constitutional Court allowed all lifers, not just the applicants, one conjugal meeting per year without in need of waiting for a change in the legislation. But there were negative side of this judgment, and it's only visible to those who know what is the application, the text of the application. In the application we actually put before judges two sets of facts, one which led to the right to artificial insemination and one to the right to conjugal meetings. The facts about artificial insemination were absolutely omitted by the judges. They just ignored them. They only ruled on the right to conjugal meetings. They refused reconsideration of Korolyov's case, so no right to artificial insemination. And they awarded legal expenses, very little, 10,000 rubles. If you calculate, it's a little bit more than $100. So imagine 12 years of litigation, a lot of work hours, and you get this $100. So this was a clear message to strategic litigators from the Constitutional Court. If once again you will come to us after 12 years of litigation, all you will get is a compensation of 1 hour for work. So that's the negative side of this beautiful judgment. So consequences, all the lifers, 1,800, and the family members received the right to conjugal meetings. The law was changed. New dorms are being built to accommodate visitors. She went to meet her husband for the first time. There are stories, and I know it from Veronika Korolyova, that some of the couples were able actually to conceive a child. Imagine, one time a year, bingo. But it didn't work for Korolyova and for other families, and they're still waiting for this judgment on right to artificial insemination. Reasons why we think Constitutional Court ruled in favor of Korolyov. I think Constitutional Court didn't want to argue with European Court of Human Rights. If they rule that it's okay 10 years without any meetings, they would look very much inhumane. But the most important is the politics. 1 year before this judgment, there was a judgment by the same court, Constitutional Court, and it says that they have a right to pick and choose which judgments of the European Court of Human Rights are applicable in Russia and which are not. And then there was a UCAS case, the 2 billion euros case, where the Constitutional Court, just 6 months before Korolyov's case, where the Constitutional Court said, this judgment is not applicable in Russia. We're not going to pay 2 billion euros. And I think they used Korolyov's case as a good example. Look, we're not bad guys. Forget about UCAS. Look at the Korolyov's case. We beautifully applied everything, all the standards that the European Court developed up till now. So we're waiting for the judgment any day now. We never know when they will come with the judgment. And now it's the second case. Not so much successful as Korolyov's case, but not less interesting. The secret organ harvesting case, and set of cases we called Alina Sablina case. So what happened? In 2014, Alina Sablina, a young 19 years old student, was hit by a car on a zebra crossing. She spent 5 days in the hospital in a coma. Her parents arrived right away and 5 days spent next to her. They spoke to doctors every single day, twice a day. And on the day Alina died, they were not allowed to see her daughter. And 6 hours later, they learned that Alina died. 1 month later, her mother, really by chance, learned that 6 organs were harvested from her body, from the body of her daughter. And 4 of the 6 organs were missing. There was an autopsy report that body does not have 6 organs, and there was a list of organ harvested, the document, which says that the transplantologist surgeon removed only 2 organs, heart and kidneys. So it means that 4 organs just disappeared. And the most important for this case, there was no record that Alina actually expressed her willingness to be donor, or there's no record that she said no. Parents were never approached by doctors to ask, what does Alina think about being a donor? Or thought maybe she said something about it before. And they never asked relatives, the mother and father, what do they think about? Would they allow donation? And we got this letter from Elena. So this is how we learned about this case. We got a bulk letter. Probably she was looking for any NGO, a lawyer, to help her to find out what's going on in the Russian medical system. And that's what she wrote to us, saying, what does it mean for her to learn that the organs were harvested in secret? For her, it's like to bury her child for the 2nd time. This is how it's painful, inhumane, degrading treatment. This is Alina. She was 19, studying in Moscow. So we try to find out what's going on. We look at the Russian law. We never knew that this law exists. Why should we bother to know? And there is a law on transplantation, Article 8. It's called presumed consent. And the meaning of this provision is that removal of organ is not allowed if the healthcare institution at the same time of the removal was informed that this person or relatives were against the removal. So this is the key words. If the healthcare institution was informed, passive. Healthcare institution, first of all, what is healthcare institution? Who exactly? You can't approach the building, the institution. You have to approach somebody. The law doesn't say anything about this. Second of all, it's passive. It's just sit and wait that somebody approach, probably doctors. But parents relatives never approach doctors with objection, or because they have no idea that the loved one is considered as a potential donor. So what happened in Alina's case? During the first hour Alina was in the hospital, a doctor called transplantology department and said, we have a potential donor, Alina Sablina, get ready. But the same doctor that didn't do anything to inform the parents. Surprisingly, it's not a secret that doctors say yes. We are not required to actively ask for consent of the relatives. We just sit and wait. That's the famous Russian doctor said this. And he said it in a documentary aired in one of the major channels. So I was thinking, why are they not hiding this? Why are they so open about this? Because of the judgment of the Constitutional Court of 2003, which considered very similar case back then. And it says, basically, it's inhumane to inform. It is inhumane to put the question of harvesting organs to a person, relatives, at the time when they learn about the death. So if you follow this logic, it's okay to remove in secret. Just nobody knows, less problems. But then we started European Convention on Human Rights and the case law, and we found at least two cases. Now there are only 2 cases against Latvia. Very similar case. If you change the name of the applicant to Alina Sablina, and Latvia, if you put Russia instead of Latvia, it's absolutely the same cases. And we learned that doing the same thing like they did in Alina's case, It's inhuman and degrading treatment, and it's violation of the right of family to decide what to do with the organs. And we brought a case to the Russian courts, district court, and then we went to all the appeals. And now the case is pending before the European Court of Human Rights. So Judge Shemakina, the district court judge, said, this is a Latvian case, so I do not apply it. But the most interesting was that some months later, already after the appeal, I happened to meet this judge in the court, and she started the conversation. She approached me and asked me, what are you going to do in this case? And suddenly you can just see that this is a real person in front of you, not the judge. She was kind of smiling, not smiling, but human face. And she was naturally interested in what you're going to do in this case, and said, yeah, what I promised in my closing arguments, we're going to go to the Constitutional Court, the European Court. And she says, please do. I could not rule otherwise if I was not told so from above. It's not clear what is above. Russian higher courts or the European Court or the phone call, I don't know. But that's what she said to me. And Moscow City courts, all the upper courts, uphold this judgment. And the argument was the same. It's not against Russia, it's against Latvia. So here's the case before the European Court of Human Rights. We have a number of issues before the judge, not only about organ harvesting, but also about how the case was conducted, how considered. And the judgment is expected any day. A few days I was interviewed by New York Times correspondents. I don't know if they will come up with this article story. Probably they're waiting for the European Court of Human Rights to deliver the judgment. I had a sort of information that the European Court is going to consider to issue the judgment this month, but you never know. So what is our next step? Find more victims. It's very difficult to find more victims. Over the 5 years, I was able to find only 5 victims, and only 3 of them wanted to go to the court. The reason is that everything is done in secret, so people don't usually know that they are relatives without organs. So it doesn't mean every single transplantation, every single removal of organs in Russia right now happening in secret, because relatives have no idea what's happening. So we want to win the case in the European Court and then come back to the National Court to do the same thing that we did in Korolyov's case, to face Russian judges with the European Court of Human Rights judges, and keep winning in the courts of minds of the people. So keys to the success in both cases, European Court of Human Rights, it's important to have access to this court. I know it's probably as important for you to have access to the US Supreme Court. Not without the political opportunity, like what happened in Korolyov's case. Media, it's very important. I was surprised how media was in favor of Alina Sablina family, because you usually expect that nobody will criticize, especially our media, not very free and open, criticize the way transplantology is functioning right now, and they were very much in favor of the applicants and questioning. So educating us lawyers, we run the Urals International Human Rights School offline courses now. We're starting this online courses. It's very important because I was able to find other applicants for other cases through my students, because they would hear a news report and they will send me a link. Right now we're litigating a case in national courts. Mardari is going to be versus Russia. It's a foreigner. His organs were removed while he was in Russia. And I learned this from Yelena Sablina. She sent me a link to a news. I found a journalist, and the journalist told me how to find the applicants. and educating judges. Oh, thank you. If you want to find more, this is a book. This one. It's in Russian. It's actually edited by me and my colleague from the US. It has 4 American stories, strategic litigation stories. It's not a legal article story. It's interesting to read. Actually. There's no quotation, no footnotes, and 4 Russian stories, including the 2 that I shared with you today in more details here. And if you do not speak Russian, you can read this. It's in English. It's a chapter in the Cambridge University Press book. It's my chapter, the draft chapter, so I can share it. You can just scan it or email me and I can share it with you later. Thank you.
I think we'll take some questions from the audience, if there are any. By all means, just raise your hand and okay, some questions. Oh, there we go. People in the back are alive. You want to just stand up and just...
Can you hear me okay?
Yeah.
Yes.
Yeah,
share-
Tim will bring you the microphone.
Can you share with us some stories of journalists and issues involving journalists that have come before the European Court? And have they, are they getting resolved on a domestic level?
Yes. Even on this case, because of limited time, I didn't mention that this case of Sablina was considered in closed chambers. So basically all the journalists were removed from the courtroom. The excuse was that the judge was protecting the right of Alina to medical secret. Although this case was not about how she was treated in the hospital in terms of healing her. It was all about whether judges informed parents had they had an opportunity to do so. But the judge closed it because nobody wants the public to learn how transplantation is taking, how does it work. So we have 2 journalists who were willing to sue. Basically, there was no domestic remedies. We brought 2 cases right to the European Court of Human Rights, and now they're being considered. It's a very long process. There are a number of cases on Article 10, right to freedom of expression and right to seek for information. There is a very successful NGO in this area, Mass Media Center. Galina Arapov is the head of this NGO. I can introduce you to her if you want. But there are a number of interesting cases, winning cases. But it's very hard to... European Convention is not a panacea. If the overall political atmosphere is this way, you cannot change it by just winning cases in the European Court of Human Rights. Will you moderate?
Sure. Yeah, I'm just going to put, yeah, please.
Yeah, I just wanted to follow up on that, the point you just made. So once the European Court has made the decision, say they decide, no, the court should have been open, the journalists should have been allowed to observe the court, which of course was years ago, right? But then that precedent has been set, and from then on, does Russia have to abide by the open court rulings?
Yes.
Okay.
Yes.
Okay.
It does not necessarily mean that it will be like that, but it really depends on the follow-up, how lawyers will argue, how they will use Sablina case in order to open the doors of the courtrooms.
Right. So in all cases, once the European Court has made the decision, the domestic courts are supposed to follow that case law, that precedent, right?
Yes.
Do they ever have to change laws to do that? And
Yeah.
are they expected to do that? That's part of the convention.
There are many examples when Russia changed the law, national law, and judicial practice. They always pay compensations, with one exception, the 2 billion case. Yeah. But within 3 months, they pay compensations. It's more difficult with general measures, like changing the law, but it's still happening. It's not perfect, but it would have been much more difficult without the European Court.
I'm sorry, I'm just gonna ask a tiny point, because I'm a medical anthropologist and I'm interested in the medical ethics part of this. Was she deceased when her organs were harvested?
Well, that's a very, very separate question. When deciding what kind of case to bring, we thought there's no chance we could establish whether she was treated enough. Was she actually brain dead?
Right.
The whole notion is brain dead is very new. It's since 1968, three Harvard professors come up with this notion. Before, death meant biological death. But you can't harvest organs from a biologically dead person. You have to sort of establish the brain death. Over the 5 years of litigation, none of the Russian medical professionals came forward to help us, even anonymously. We now have one sort of a professional